Chairman, I wanted to make a point that follows on Senator Feinstein's point about the Attorney General nominee's comments related to transparency and release of the special counsel report. As Senator Feinstein noted, his top line was terrific. He wants to be as absolutely transparent as possible, consistent with the law. But we're both lawyers, and we know that there are weasel words that can be put into sentences. And the question of what transparency is consistent with the law is a ginormous loophole in his transparency pledge. And there are two specific areas where I think we should have concern about that ginormous loophole. The first is the department's tradition that it does not release derogatory investigative information about an uncharged person. This is the rule that Jim Comey violated so flagrantly and so inexcusably. The question how that rule applies to this report is an interesting one. And the particular question that is of interest is, what if the reason that President Trump is an uncharged person within the meaning of that department's tradition is the OLC opinion that says you can't indict a sitting president? What if there actually is an indictment-worthy case to be made, and they then take the position that, well, he's an uncharged person, and therefore this is derogatory information, and we're not going to talk about it? There are a million reasons why, in the special counsel context, when the President of the United States is a target, that rule creates, there are a whole bunch of new considerations. But it ought to be a very simple one, that if the only reason he's an uncharged person is because of OLC's internal, untested, never signed off on by any judge policy, it makes him an uncharged person. We got to get to the bottom of that. That's, I think, a worthy question for this committee to settle before we're asked to vote on this guy. The second is, what if the reason that he refuses to be transparent about the special counsel report by reason of the law has to do with an assertion of executive privilege by the White House? Particularly, again, an assertion by the White House completely untested in any court. He just says, we're going with it. That takes the transparency of the report out of the special counsel process in the hands of the Attorney General and moves it over to White House counsel. And I think we have a serious concern about that problem because in this committee, we have seen such flagrantly false and bogus assertions of executive privilege by this administration already. So again, these are two enormous windows that could be closed with clear answers, and I hope very much that we can get those answers before we're obliged to vote on Mr. Barr. The question of executive privilege causes me to revive questions that I asked the previous chairman that I think would be productive areas for this committee to do some work. The first is, I think it's appropriate for the Congress to know what a president of the United States has by way of foreign business interests. That seems to me a pretty straightforward question and one that's pretty hard to defend and answer, no, we don't need to know that. So I think we need to get an answer to that, and I propose to Chairman Grassley that we bring in somebody who is respected and neutral and can do a study for us, like a forensic accounting report that says, here are the foreign business interests of the president. I think we need to get to the bottom of executive privilege and come up with a committee process and rule for when we'll accept the assertion and when we won't, because we've been extraordinarily sloppy about allowing executive officials to get away with non-assertion assertions of the privilege. I think that we ought to take a look at whether Donald Trump Jr. was truthful to our committee. There have been very public questions raised about whether he was truthful or not. We are the committee before which he testified. Those seem to be reasonable answers to try to run down any witness who isn't truthful to our committee. That's a question that we ought to take a look at. And finally, I've raised before and I'll raise again, I don't know that the House would ever look at it, but the prospect that there was coordination between House members or staff and the Trump team to use the House and congressional oversight as a means for trying to sabotage or impede the special counsel investigation remains to me an open question. So I just wanted to flag those again. I've raised those all before under the previous chairman, and I thank you for your patience. I know you're the only member of the Republican Party here right now.
Well, I think y'all are very interesting. I don't know about the other people over here, but so that's a good point. I hadn't thought about that. What if the legal counsel said, OLC folks said, you can't indict a sitting president, so therefore, yeah, so we'll talk to, that's actually.
I think we can get that question
Yeah, I
settled.
think that's a good question to get an
And I think
answer to.
ditto, getting a responsible review of the executive privilege assertion, if that's
Yeah,
going to be
absolutely.
an assertion that prevents release of the transcript.
Yeah.
I don't know why they're being dodgy about those answers, but one looks suspiciously at
We'll give him a
dodgy
call.
answers.
We'll give him a call.
Thank you.
Who's next?